Alright, so welcome back to part 2 of contract law on chapter 8, promissory estoppel. Okay, waivers and promissory estoppel. Alright, so last we're talking about intended to be acted upon on the promissory estoppel. Section 2. Okay, in order for the promissory estoppel to apply, there must be an intention to act. In the case D and C Builder Limited versus Reese, the debtor refused to pay the creditor the full amount and offered to pay 2/3 of the amount. The debtor knew the creditor was in need of money, and the creditor accepted the money on the debtor's term. The creditor later brought up a claim for the remaining balance of the money owed. Lord Denning held that the promissory estoppel would apply. The reason is that the partial payment of the debt constituted a reliance or acting upon the promise to discharge the debt to engage the doctrine. Discharge the debt to engage the doctrine. Okay, unquote. The main principle in this case is that the creditor is not allowed to enforce their legal rights on the debtor only when it would be inequitable for the creditor to insist. It is inequitable for the creditor to insist on the balance. This is a type of promissory made under duress, and it should not be estoppel. The court will not allow this promise to be accepted in partial payment on a debt on the basis that it was created under duress. In Lord Denning's view, it is not important that the act of fulfilling the promise is detrimental in any way. All that is needed is the promisee being led to act in a way that he would not normally have done. In both high trees, it is not important that the tenant was prejudiced by the landlord's willingness to accept less than the regular price. All that matter is the action on the promisee. Alright, in the case Society Italo Belgo Pure Less Commerce versus Palm and Vegetables Oil, the Post Chaser, 1982, Geoff required that there should be evidence of significant detrimental reliance by the promise in order to apply the doctrine of promissory estoppel in a waiver. It must be inequitable to allow the party who waives his rights to revert. Alright, so next section, number 3, nature of undertaking. The promise gives, quote, rise to a promissory estoppel must be voluntary in nature, unquote, page 283. Alright, Lord Denning withheld the doctrine of promissory estoppel in the case D and C Builder because the plaintiff had taken advantage of the vulnerability of the creditor, unquote, page 283. The defendant was not able to rely on the equitable doctrine because the settlement was procured by intimidation. The defendant knew that the plaintiff needs the money and took advantage of the plaintiff's need by offering him a discharge of the debt in return for partial payment. Out of this case, other doctrines have been developed to analyze the voluntariness of undertaking in a contract. Any contract entered into under duress, undue influence, or in circumstances of unconscionability are unenforceable, page 284. Alright, so again, contracts entered under duress or undue influence or circumstances of unconscionability are unenforceable. Each party must enter into the contract willingly. The promise or undertaking does not have to be explicit. It can be explicit or inferred from words, conduct, or signs from the promisor. If we look at the Hudges case, the promise was inferred from the leaser's failure to indicate that the lessee that the notice period for the repairs would not be suspended during the negotiations. Thus, the leaser understood that there will be no repairs done during the negotiation. In the case John Burroughs versus Subsurface Surveys, the passive conduct was not considered a waiver of its rights to seek enforcement of the contract. When there is no consideration of any kind, any relaxation of the terms must be clear and unequivocal. Just because the plaintiff was not strict on the late payment, it doesn't mean that it will be strict in the future late payments. The Supreme Court had two reasons for this decision. Okay, number 1. Undertaking gives rise to a waiver or estoppel must be the product of a course of negotiation. Number 2. The seller's friendly indulgence with respect to the individual late payments were more consistent with the undertaking that the plaintiff had not given up its right to a timely performance. Page 283. Right? So section 4, reassertion of rights upon notice. As in the case of the high tree, the promisor could reassert her rights on the full payments of the rent if there was a reasonable notice. The high tree case did not have any notice. The landlord continued to accept the rent at the lesser amount. He accepted it to a point when the whole building was full. The main purpose of doctrine of promissory estoppel is to prevent any losses to the promisee from relying on the promise. McCamus states that if a promise has been given that it is to last for a period of time, the promisee's reliance interest could be protected by a reasonable notice. In the Residential Tenancy Act of British Columbia, the landlord always needs to give a reasonable notice. The landlord needs to give a reasonable notice to increase rent after a 1-year lease. She would also need to give a reasonable notice if she would like to visit the place. If there was no reasonable notice, the effect would be defined in the Saskatchewan River Bungalow Limited versus Maritime Life Assurance Company, 1992. In this case, an insurance policy lapsed and the insurance company sent the life insured a lapse of policy notice that had no specification on the future date on the lapse notice would be effective. The insurance company assumed that it would be effective as of its own date, but the defendant promisee claimed that the notice was unreasonable, thus it should not be given any effect. The court claimed that the unreasonable notice will have effect after a certain reasonable period of time. The reason behind this is that the promisee would have been aware of the existence of the intention to resile. The promisee reliance interest would be protected by the expiry of the reasonable period of time before the reassertion of the strict rights under the original agreement, page 287. Alright, next part here we're looking at proprietary estoppel. Alright, part D, proprietary estoppel. The doctrine of promissory estoppel is not proven a cause of action. However, there is a rule that states that gratuitous promise in relation to the creation of an interest in the land will be enforceable. McCamus states that the promisee will have reliance of the unequivocal promise that the promisee will build or fix a building on the promisor's land with expectation that the land will be for the benefit and or the use of the promisee. If the promisor refused to carry out the promise, there would be a problem. In the case Inwards versus Baker, a son built a house on his father's land because his father agreed to allow him to use the house as his primary residential property. The son built the house on the land and lived there for many years until the death of his father. The trustee of the estate tried to recover the land, but the Court of Appeal allowed the son's expectation to continue. The trustee will not be able to defeat the son's expectation of continuing to live on his father's land. Alright, so let's see here. I guess right now we'll actually end it off from here. Okay, that is the end of this part here, part 2 of promissory estoppel and waiver. Okay, so until next time, we'll look into proprietary estoppel, and we'll continue on looking into the case Crabb versus Arkan District Council. Alright, it should be an interesting case we should look at. Alright, so until then, take care and stay classy.